This is the Wizard News. Leo Jones, a black man, was convicted and sentenced to death by an all-white Florida jury in 1982 for the killing of a white police officer. The conviction rested on a key witness who later recanted his testimony, and a coerced confession from Mr. Jones, which was written by the police officers interrogating him. Both officers were later fired for a pattern of misconduct, including police brutality. Despite the serious doubts around Mr. Jones's conviction, the state of Florida executed him in 1998 by electric chair. Mr. Jones's case is emblematic of pervasive issues in death penalty cases. One of the first lines of defense against miscarriages of justice is a diverse, representative jury, which is much more capable of fairly weighing evidence, holding the government to its high burden, and protecting the rights of those accused of crimes than an all-white jury. Juries are an integral part of our justice system. Their goal is the determination of truth and the fair and equitable application of law. Other than voting, serving on a jury is the most substantial opportunity that most citizens have to participate in the democratic process. This is because of a process known as death qualification, which dictates that to serve on a death penalty jury, a prospective juror must be willing to impose the death penalty. Those unwilling to impose the death penalty are excluded from jury service. Black people are more likely to oppose the death penalty and, as a result, are disproportionately excluded from death penalty juries. But in death penalty cases, juries are rigged to be more conviction-prone, friendlier to the prosecution, and to exclude black community members. Black opposition and skepticism about the death penalty is unsurprising, given racial bias in the administration of the death penalty. The line between racial terror lynchings and capital punishment, and racial disparities in the criminal legal system. The American Civil Liberties Union, ACLU, is challenging the racist death qualification jury selection process in cases in Florida and Kansas. Not until the passage of the 14th Amendment and the 1875 Civil Rights Act were black people, newly recognized as citizens in the eyes of the law, legally guaranteed the right to serve on juries. Even with the passage of these guarantees, discrimination remained a reality, especially in the former Confederate states. Overwhelmingly, black people accused of crimes continue to be judged and sentenced by all-white juries. Conversely, black people who were victims of racial violence and racial terror did not find justice in the courts. The white perpetrators of violence, if even brought to trial, judged by all-white juries. Racial disparities in mass incarceration and racial bias in the death penalty go hand in hand with the exclusion of black Americans from juries. Participation in the jury, a voice in the just administration of criminal laws. These are essential acts of citizenship and democracy. Source: American Civil Liberties Union, ACLU, April 14th, 2023.